The claimant was employed on 2nd February 2007. It is also not in dispute that the claimant's employment had been terminated by dismissal. The dismissal letter to the claimant is dated 2nd October 2021 from the first defendant. I have reproduced the content of the dismissal letter. In this dismissal letter, the claimant's dismissal was immediate, implying that it took effect from the date of the letter. Again, the reason for the claimant's dismissal is the allegation that the claimant presented fake certificates and that he committed serious misconduct under the civil service rules, for which the disciplinary procedure in accordance with Rule 030302 to 306 is applicable. The dismissal of the claimant from service by the above letter is the course of action of the claimant in this suit. The first and second claims sought by the claimant is for a declaration that the termination of his employment by the first defendant is in breach of the provisions of the Niger State Civil Service Rules, the rules of fair hearing, and therefore unlawful, null, and void. In a suit where an employee complains of unlawful termination of his employment, the employee has the duty to plead and prove the terms of his contract of employment, how the employment can be terminated under the condition of service, and the manner the terms of the contract were breached by the employer when his employment was terminated. See WAEC versus Oshonebo 2007, Petroleum Training Institute versus Matthew 2012. Thus, in this case, before the court can make the declarations sought by the claimant must have pleaded the condition of service regulating his employment and the facts showing what made his dismissal to be unlawful. In paragraphs 9 and 10 of the statement of facts, the claimant pleaded that he was dismissed from service in October 2021, but before the dismissal, there was no query or petition served on him. Are you in this matter? If you are not, you can take fresh air outside. Okay, maybe you should open the window. But there was no, before the dismissal, there was no query or petition served on him to know if there were allegations made against him contrary to the Niger State Civil Service rules. In the reply to the statement of defense, the claimant pleaded that his appointment enjoys statutory flavor and can only be terminated as provided for in the Niger State Civil Service rules. Also, in paragraphs 11, 12, 16, and 16 of the reply, and also paragraph 6 of his defense to counterclaim, the claimant averred that contrary to the Niger State Civil Service rules, he was not informed orally or in writing as to why he was dismissed. There was no query or communication to him before the dismissal. He was not called before any disciplinary committee before he was dismissed. From the averments of the claimant, he pleaded that his employment is regulated by the Niger State Civil Service rules, and he front-loaded a copy of it with the complaint. The defendants did not deny the fact that the claimant's employment with the first defendant is regulated by the Niger State Civil Service rules. I have also seen that the first defendant relied on the Niger State Civil Service rules to effect the dismissal of the claimant, as stated in the dismissal letter. It is therefore clear to me that the claimant's employment with the first defendant was regulated by the Niger State Civil Service rules. The Civil Service rules is made pursuant to powers conferred by the Constitution on the respective Civil Service Commission of the states. For this reason, the Civil Service rules has been regarded as a subsidiary legislation and accordingly has the force of a statute. See Federal Civil Service Commission versus Laoye 1998. It is now settled law that the Civil Service rules confers the employment which it regulates with the status of employment protected by statute. And in such an employment, the employee cannot be removed from the employment without strict compliance with the procedure set out in the Civil Service rules. In Federal University of Technology, Yola versus Mewuya 2013, it was held that Civil Service rules confers on public servants a legal status that goes beyond that of ordinary master and servant relationship. They cannot therefore be properly or legally removed from their employment without strict adherence to the civil service rules. See Nawa versus Attorney General Cross River State 2008. Accordingly, as pleaded by the claimant in his reply to the statement of defense, his employment, which is regulated by the civil service rules, enjoys statutory flavor and can only be terminated in accordance with the provisions of the Niger State Civil Service rules. The claimant pleaded how his dismissal was done in violation of the provisions of the rules. He said he was not given any query before he was dismissed from service. He also said he was not called before any disciplinary committee before he was dismissed. In the final written address of the claimant, learned counsel for the claimant, Mr. Abdulkadir, set out the provisions of Rule 04308 of the Niger State Civil Service Rules 2004 and submitted that the procedure in the rules was not followed when the claimant was dismissed from service on 2nd October 2021. I have examined the provisions of the Niger State Civil Service Rules front-loaded by the claimant. The procedure for dismissal is contained in rule. Can somebody come and assist me? One of the clerks. Thank you. Put on the air conditioner. It's accessible. Yeah, you can just keep with the lights on. I don't think so. It's off. You video. I connected it. It's okay. Let's just continue. The procedure for dismissal is contained in Rule 04308. The summary of the procedure for dismissal is as follows. I have copiously included the content of that rule in verbatim, and it is embodied in the judgment. Where they are numbered from 1 to 7, 1 to 6 in Roman figures. Where the allegation against an officer or the misconduct committed by the officer is one which will result to dismissal, the above procedure must be followed. It is therefore obligatory on the first defendant to comply strictly with the procedure before a valid decision of dismissal of any of his employees can be taken. The first step in the procedure for dismissal is for the first defendant to give a written query to the claimant and require the claimant to submit a written representation in response. They don't even let me watch what I like to watch. Eh? And it will be noisy. Thank you. And to give him opportunity to defend himself against the allegation. The first defendant must, as a necessity, serve a query on the claimant before a dismissal decision can be taken against the claimant. Also, where a committee is set up to investigate the allegations, the claimant shall be invited to appear to defend himself, be allowed to put questions to witnesses where any was called, and be allowed to call witnesses in his defense. Now, the complaints of the claimant against his dismissal are that he was not given any query and he was not called before any disciplinary committee before he was dismissed. These averments of the claimant shifts the burden on the defendants to show that the dismissal of the claimant was done in compliance with the procedure laid down by the Niger State Civil Service rules. The defendants confirmed in their statement of defense that the claimant was dismissed from service, but did not explain the procedure followed before the dismissal was effected. Other than the proceedings in the screening exercise, the defendants did not plead any facts relating to any disciplinary steps or procedures taken against the claimant before the dismissal was communicated to him. In paragraph 11 of the counterclaim, the defendants pleaded that the disciplinary committee known as the Establishment Committee was set up to look into the issue of the fake NCA results, and the committee recommended for the dismissal of the teachers found wanting In these averments of the defendants, it was not stated whether the staff whose cases were looked into by the committee included the claimants. It was also not stated whether the committee gave notice of any allegation or query to the claimant or gave the claimant opportunity of defense before his dismissal. It was also not stated whether those the committee recommended for dismissal included the claimants. The defendants pleaded the report of the committee, but it was not front-loaded. In the final written address of the defendants, learned counsel for the defendants, Mr. Abubakar Suleiman, relied on Rule 04437 of the Niger State Civil Service Rules to submit that any person found to have presented false information or concealed facts before or after employment, such a person is liable to be summarily dismissed from service immediately the falsehood is detected. Counsel seems to suggest that the dismissal of the claimant was done under Rule 04437 of the Niger State Civil Service Rules. If that was the case, the defendants ought to have pleaded so, but no fact was pleaded to the effect that the claimant was dismissed summarily under Rule 04437 of the Niger State Civil Service Rules. Therefore, I do not think the applicable provision to the case of the claimant is summary dismissal under Rule 04437 of the rules. In any case, the dismissal letter clearly stated that the claimant committed an act of serious misconduct for which the disciplinary procedure is provided in the Civil Service Rules. In other words, the claimant's dismissal was for committing an act of serious misconduct. Rule 04402 provides that the disciplinary procedure for serious misconduct shall be in accordance with Rule 04302 to 04308. That is to say, the allegation against the claimant was not one for summary dismissal, but one which must go through the disciplinary procedure for dismissal. The claimant was dismissed for presenting fake educational certificates. I have seen the letters from the Niger State College of Education dated 6 July 2021 and 6 November 2021. The claimant's name is number 20 at page 3 of the letter, where the Niger State College of Education said the claimant's result is not authentic. It was after this verification letter that the claimant was dismissed on 2nd October 2021. There is no doubt that the act of presenting fake educational certificate, if proven, is a grave and serious misconduct for which the appropriate punishment under the Niger State Civil Service Rules should be applied. However, by virtue of the fact that the employment of the claimant is one protected by the Civil Service Rules, he cannot be dismissed from service at the whims of the first defendant. He ought to have been confronted with the allegation of presenting fake NCE and given opportunity to defend the allegation before he could be dismissed from service. What the first defendant did was to summarily dismiss the claimant upon receiving the verification letter from Niger State College of Education without following the procedure for dismissal provided in the Niger State Civil Service Rules. The result of the case of the defendants is that they have failed to show that the provisions of Rule 04308 of the Niger State Civil Service Rules were complied with before the claimant was dismissed from service on 2nd October 2021. I find that the dismissal of the claimant was done in violation of the procedure provided in the Niger State Civil Service Rules for dismissal. His right to fair hearing was also violated. Where an employee whose employment is protected by statute is removed from the employment in a manner which violates the procedure or in the manner not in line with the condition of service, the removal is null and void and liable to be set aside. See Adeniyi versus Governing Council of Yaba College of Technology, 1993. And in Oloruntoba Oju versus Abdulrahim, the Supreme Court held that when an office or employment has a statutory flavor in the sense that its condition of service are provided for by the statute or regulations made thereunder, any person in that office or employment enjoys a special status over and above the ordinary master and servant relationship. In the matter of discipline of such an employee, the procedure laid down by such statute must be fully complied with. If not, any decision affecting the right or reputation or tenure of office of that employee will be declared null and void. Where a contract of service enjoys statutory protection, the latter can only be terminated in the manner prescribed by the governing statutory provisions, a breach of which renders the act ultra-vires and void. Therefore, having found that the first defendant dismissed the claimant in violation of the provisions of the Niger State Civil Service Rules and in breach of the claimant's right to fair hearing, I declare that the dismissal of the claimant from service is unlawful, null, and void. The dismissal of the claimants from service by the first defendant is also hereby set aside. In Relief 3, the claimant sought to be reinstated to his employment, while in Relief 4, he sought an order directing the defendants to pay him the sum of 1,441,318 naira 4 kobo, being his salary arrears from November 2022 to July 2024, and up to date of this judgment. Order for reinstatement and payment of outstanding salaries are usually granted to an employee whose employment is protected by statute, but was unlawfully removed from the employment. There are consequential reliefs granted to put the employee back to his employment and to be paid all outstanding salaries and other entitlements from the time of the unlawful removal. See Omidiora versus Federal Civil Service Commission 2008. Kwara Polytechnic Ilorin versus Oyebanji 2008. Accordingly, the claimant is entitled to be reinstated to his employment forthwith and to be paid arrears of his salaries, allowances, benefits, and emoluments due to him from the date of dismissal to the date of judgment in this suit. In Relief 5, the claimant sought to be paid general damages for the unlawful termination of his employment. Other than the dismissal, the claimant did not plead any other facts to entitle him to this claim. The fact that he is to be paid the arrears of his salary for the period he was not rendering any service is enough to compensate him for the damages he suffered. The claimant did not also plead the facts which will entitle him to the sum he claims as cost in Relief 6. To conclude my decision on the case of the claimant, I hold that the claimant is entitled to Reliefs 1, 2, 3, and 4. Relief 5 and 6 are refused. Now, the decision of the defendant's counterclaim. In the counterclaim, the defendant sought an order directing the claimant to refund the sum of 3,608,307 naira 8 kobo, being salaries paid to him in excess as an NCE holder over the period of 170 months. The case of the defendants is that the claimant presented an NCE certificate, and acting on that misrepresentation of the claimant, he had obtained an NCE. The defendants upgraded, promoted, and paid salary due to an NCE holder to the claimant. It was in the screening and verification exercise that the first defendant found out that the NCE certificate presented by the claimant in 2007 was not authentic. Since 2007, the claimant had been illegally receiving the salary of an NCE holder, which is the sum of 55,285 naira 54 kobo monthly. The defendants said they are entitled to refund of the salary received by the claimant since 2007. The reason the defendants want the salaries paid to the claimant returned is that the claimant presented a fake NCE to obtain the employment, and he fraudulently misled the defendants into paying him salary of an NCE holder. They've taken light now. Open the window. The defendants have, by their averments, made allegations of fraudulent misrepresentation and forgery against the claimant. Allegations of fraud or forgery are criminal allegations. In civil proceedings, where allegations of crime is made, it must be proved beyond reasonable doubt by the party making the allegations. See Sani Omotosho versus Obidairo 2014. Also, PIP Limited versus Trade Bank Nigeria Limited. Yeah, you can move the curtain a bit, but not too much, so that's fine. The facts pleaded in the statement of defense and counterclaim of the defendants are not sufficient to prove the allegations of fraud and forgery made against the claimant. By their averments, The defendants confirmed that the claimant presented the alleged fake NCE when he was employed in 2007 by the defendants. The claimant has been in the service of the defendants since 2007, and it was only in 2021 the defendants claimed to have discovered that he used a fake NCE for the employment. The defendants who employed the claimant did not conduct due diligence to verify the qualification of the claimant before employing the claimant in 2007. And within the period of about 14 years that the claimant was in service, the defendants never took steps to find out the authenticity of the claimant's NCE. The defendants never took steps to find out the authenticity of the claimant's NCE. Defendants have themselves to blame for not taking proactive steps to confirm the genuineness of the educational certificates presented by persons they employ into the civil service. The result of the foregoing is that the defendants are not entitled to their claim in relief one of the counterclaim. I also find that the defendants did not make out any case to entitle them to reliefs 2, 3, and 4 sought in the counterclaim. Consequently, the counterclaim fails and it is dismissed. I make the following orders. It is declared that the termination of the claimant's employment by the first defendant is in clear breach of the terms and conditions of service as contained in the Niger State Civil Service Rules. 2, it is declared that the termination of the claimant's appointment by the first defendant without fair hearing is unlawful, wrongful, and void. 3, a consequential order is made, setting aside the dismissal of the claimant and directing the first, second, and third defendants to reinstate the claimant to his employment immediately. 4, an order is made directing the first, second, and third defendants to compute and pay to the claimant all the arrears of his salaries and allowances from when his salary was stopped to the date of this judgment. The defendants are ordered to comply with this order within 30 days from today, and failure to do so, the total sum accruing to the claimant shall attract 10% per annum until the time it is paid to the claimant. The sum of 500,000 naira is awarded to the claimant as cost. Judgment is entered accordingly. Thank you. So, what is my pen? You can just find evidence. Thank you. I don't know. My people are just sorry. Thank you. Judgment delivered in NICM 2024.
My Lord, we are most grateful for the industry. We're very grateful. Thank you, my Lord, for the claimants.
Thank you very much. So this judgment that I have just read in MN 18,
yes, my Lord,
is similar to the judgments in the cases listed in this category, which would include MN 19 to 32, 34 to 38, and 44 to 47. We are trying our best to produce all the judgments individually, having regard to the differences in figures and years and peculiarities of each case. It's taken a long time. I usually would complete writing judgments before I deliver them, but because we are constrained for the 90-day rule, which will expire on the 27th, I decided to read. Some of them are ready, quite a number of them are ready, but you might need to give us up to Monday next week, thereabout, before you can have physical copies of all the judgments. Yeah, we are working assiduously.
We are very grateful, man. Thank you for the industry always.
Thank you. And
An gama kenan.
so, the judgment is the NICN 18 has been delivered. The judgments in the other ones, 19 to 32, 34 to 38, and 44 to 48, being similar in content to MN 18, are hereby deemed as read. Each of the judgments will be made available to parties within a few days. Thank you.
Thank you, my lord.
Thank you. So bring 33. As soon as the green light now, you should go and start printing the ones that are ready. Are you sure you will not leave out behind for me? Put it there. Put it there. Okay, so uh, uh, where is that in paper now? Thank you so much. Let me not finish your ink before. Thank you. In the same vein, I'm going to read the judgment in MN 33, and the judgment in MN 33 would apply to 48 to 52. Right? So those ones might be ready tomorrow because we're almost done. I think we're done. It's just to edit and then get them printed out, but at least you can all have them at the same time if you wish. Once they are ready for collection, the registrar will notify you. Then you can send some.
Abuja and Niger State Universal Basic Education Board and others. Lord Party Starting.
Appearances. Yeah. Yeah. B.O.
Is the claimant safe?
Can I have the appearance, any representation for the claimant, please? This is MN33. They are there. Or am I muted? I'm not muted.
Respectfully, my lord.
Yes.
Yeah, sorry, my lord. The network is a bit shaky. MN33, Shabajia.
Yes.
Yes. Appearances,
Respectfully,
please. Yes.
respectfully, my lord, I am Hadiza Noura Alpha, my lord.
Yes.
My lord, I still appear with A.O. Adeboye.
Yes.
Ghazali Rabiu,
Yes.
and N.M. Njuma, my lord. My
For
lord,
the
together we
claimant.
are the claimant. Yes, my lord. Thank you, my lord.
Yes. Thank you. Yes. Yeah. Yes. 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 VN. M for N for Nigeria. Okay. Ogbulu. How is that spelled? LU. Okay. OB. P. J. Yes. Yes. So, judgment in MN 33 2024, which, by the way, In terms of similarity, they are basically the same with the other ones, except that we have already done the classifications for two reasons, both because the appearances are different. These ones are not represented by state counsel in the defense, and then the facts of the case might be slightly, they are basically the same, of course, because pleadings were not drafted by the same counsel. There are bound to be differences. So in areas, yes, 50 up to 52 now. You are a different counsel. What's your name? You want me to classify you as counsel for the claimants or for the defendant? You appear alone? For the defendants in MN 50. Only 50. Okay, that's fine. I've noted that. So I'll go straight to read the judgment where necessary, because I have painstakingly read the entire judgment in 18. I might omit reading some parts of this one because it's lengthier, and but they are basically on the same basis. The claimant instituted this action by a complaint filed on 22nd July 2024. His claims against the defendants are as follows. Again, there are 6 claims listed, and in this one as well, there is a joint statement of defense and a counterclaim filed 20th January 2025. This is also, there are 6 reliefs sought in the counterclaim. They are listed at 1 to 6. The statement of defense was accompanied with 2 witness depositions, that of Jibril Hassan Abubakar and Jibril Mohammed Ibn. Also in this one, the proceedings of 28th October, Learned Counsel for the parties, MW Abdul Kadri and AIEH Rika, informed the court that the parties have agreed to adopt the trial on record procedure. I have earlier read what the trial on record procedure means, as contained in Order 38 through 33 of the rules of this court. Again, it is repeated here. I have also summarized the case of the claimant and that of the defense and counter-claimant, as well as the reply and defense to counter-claim. It's clearly summarized there. And then I have made statements regarding the written addresses to the effect that their content will be considered in the course of the judgment. The decision on the claims of the claimant, again, from the facts pleaded and the appointment letters front-loaded, it is not in dispute that the claimant was employed as a teacher into the service of the second defendant by the first and third defendants. He was employed 1st April 2003, and his appointment was terminated by dismissal on 13th January 2022. His letter of dismissal has again been verbatim cited and quoted in the body of this judgment. And then in the dismissal letter, the dismissal of the claimant was immediate, implying it took effect from the date I take it that this is it will be taken as read, haven't been exactly in the same, the same wordings, except for the difference in details, which I have stated earlier.
I lost some.
It's coming back.
I have delivered the judgment in MN 33, and if council will wait a little, we can actually have MN 18 and any other ones that are ready printed out. Otherwise, we'll just leave it, and the MN 33 is also ready, and as well as those in the category. Yeah, so we can sort that out administratively. Yeah, you can get them together. Thank you very much. So that's it. Thank you very much. Thank you. All right. So thank you.
My Lord, for the claimant, we are grateful. Though at a point,
Thank
my
you.
Lord's mic was mute. We were sending chats that my Lord's
Oh,
mic
I'm
was
so
mute.
sorry. I didn't take note of that, but thankfully you get. Oh, I'm so sorry. I'm just seeing it now. There was a time there was a power fluctuation, and I think a call was trying to obstruct, and then I ignored the call, but perhaps I
Yes.
needed to revisit. But it's fine. The judgments are basically the same with MN18. The difference is the difference in counsel. So they'll be
Okay.
ready for collection in a short while, as I'm staying back to do all that. As soon as they are ready, the registrar will reach out to you, and then you can pick up your judgments.
As
Thank you
copies, we are
very
most obliged, my lord. Thank you for the
Thank
industry.
you. Thank you. All right then. Thank you. Katigi. Thank you.
Wai call ne ke so ya shigo. To. Yeah.